adaptability, and the ability to persuade with clarity and confidence. Regardless of the outcome, your participation here is a testament to your commitment to excellence.
It should be on the main page.
As we embark on this journey over the next few days, I encourage all of you to engage, learn, and most importantly, enjoy the process. May this Moot Court competition serves as a stepping stone to the greater achievements in your legal careers. The lamp signifies the dispelling of the darkness and the illumination of knowledge, aligning perfectly with the essence of this competition, which seeks to enlighten and inspire the young legal minds. Let us begin this event with the lighting of the ceremonial lamp, and it is my honor to invite our esteemed dignitaries to join us for the lamp lighting ceremonies. I request everybody present here to kindly rise as we commence this auspicious ceremony. Thank you, esteemed dignitaries. As we move forward with this inaugural ceremony, it is essential to understand the vision and the significance of the 7th GDGU CIArb India International Commercial Arbitration Moot Competition 2025. To provide us with the valuable insights into this prestigious event, I am honored to invite Ms. Shraddha Oberoi, Assistant Professor at the School of Law, GDGU University, and Faculty Convener of the Moot Court Society, to share her thoughts and shed light on the journey that had brought us this competition to life. Thank you.
Thank you, ma'am. Good evening, esteemed dignitaries, honorable guests, respected faculty members, student volunteers, and dear participants. It is my absolute privilege to welcome you all to 7th GDGU CIArb International Commercial Arbitration Moot Competition 2025. As the faculty convener of the Moot Court Society, I am delighted to see such a distinguished gathering of legal luminaries, academicians, and budding legal minds coming together to celebrate the spirit of advocacy and arbitration. This year's Moot proposition is centered around the dynamic and ever-evolving field of intellectual property and pharmaceutical laws within the realm of commercial arbitration. This theme is relevant in today's world where disputes over patents, licensing, and public health intersect with global trade and commerce. Participants will have the opportunity to tackle these complex issues, refine their legal reasoning, and engage in high-level advocacy before some of the most distinguished arbitrators in the field. The next 2 days promise to be an exhilarating journey of intense courtroom disputes, I would say battles, strategic arguments, and thought-provoking legal discussions. Participants will step into the shoes of legal counsels, advocating the cases with precision, confidence, and persuasive oratory. Each round will test not only their understanding of the law, but also the ability to think on the feet, respond to judicial interventions, and present compelling arguments before a panel of esteemed adjudicators. I extend my heartfelt gratitude to our chief guest, Honorable Justice Venkateshwar Singh, for gracing this occasion. Your presence is an inspiration to every participant here today. I also express my sincere appreciation to our respected Vice Chancellor Ma'am, Dr. Kim Menzies, and our Dean, Dr. CIArb, for their unwavering support in fostering a culture of academic excellence. To all the participants, I wish you a stimulating and enriching experience. May this competition ignite your passion for arbitration and push the boundaries of your legal acumen. Mooting is not just about winning. It is about learning, growing, and refining your advocacy skills. With that, I welcome you all once again and look forward to an intellectually engaging competition. Thank you.
Thank you, ma'am, for your insightful words and for sharing the vision behind the 7 GDGU CIArb India International Commercial Arbitration Moot Competition 2025. Your dedication and leadership as the faculty convener of the Moot Court Society have been instrumental in shaping this platform for the young legal minds to excel in the arbitration advocacy. I request Professor Dr. Kim Menzies, Vice Chancellor, GDGU University, to felicitate our esteemed chief guest, Honorable Justice Venkateshwar Singh, the Judge, Supreme Court of India, as a token of our deep respect and appreciation for his gracious presence at this event. Officially commence the 7th GDGU CIArb India International Commercial Arbitration Moot Competition 2025. It is my privilege to invite Dr. CIArb Raghunath, Dean School of Law, GDGU University, to deliver the welcome address and extend his greetings to our esteemed dignitaries, faculty members, and talented participants.
Good evening, everyone. Honorable Mr. Justice Venkateshwar Singh, Honorable Vice Chancellor Professor Kim, dignitaries, my dear faculty members, students, and participants of the Moot Court competition. Now it's one of the most beautiful days in GDGU Law School's history that we are setting the 7th GDGU Moot Court competition on a different note. We have gained significant growth over the last 7 years because GDGU Moot Court CIArb partnership happened almost 7 years back. And it has evolved itself into one of the most sought after arbitration moot court competition in the whole of the nation. Now, to begin with, I would like to express my sincere gratitude to Justice Venkateshwar for sparing his valuable time because he is coming to this campus right after the court sessions. Taking a long route from all the way from Delhi, covering the traffic, and I'm really appreciate your magnanimity and let me truly appreciate your effort for joining us, and thank you so much for gracing this occasion for the young and vibrant law students. It is again one of the most happiest thing, though we have invited Justice Tejas Kadia, but he's unable to join us as a guest of honor. But the best part is that he's been elevated as the judge of Delhi High Court, and I think it's the best occasion for us to celebrate also because he's been a very close friend of GDGU School of Law, as well as he has been visiting the campus on earlier occasions as well as a partner of Amarchan Mangaldas, and now he has on a altogether different mission. And I'm really happy to, with the help of, with the permission of your Lordship, I would like to share that we all are going to be a part of his elevation and celebration as a part of his elevation. So I think he deserves a huge round of applause. Mooting has always been an integral part of the legal education. I mean, because every time it gives a clinical exposure, but then more than that, it's a passion for law students. It gives you an immense opportunity to learn the true art of advocacy. It all starts with the research, then with the research, then you further develop your case, the way you articulate and the way you present it in a forum. Sometimes I always feel that I see students performing way better than the lawyers, because I've spent almost 7 or 8 years as a practicing lawyer before I joined academia. So this is an amazing opportunity for all the students, to take up this challenge, spend a lot of time, because I know at least you must have spent months together for preparing this competition. And this is an opportunity to learn, to grow, and more than that, it's an opportunity for all of you to meet. I'm happy that about 100 plus students from different parts of the country, from one of the top tier law schools is here. So it's a great opportunity for you to interact and meet each other, share your knowledge, and you're also getting an opportunity to meet almost 50 leading arbitrators and academicians as a judge. So it's an opportunity to get your feedback, reflect what you have learned, and improve further to be in the art of advocacy, and for that matter, specifically in the field of arbitration. Now, I'm really happy that this event, the 7th edition of GDGU CIArb, originally founded in collaboration with CIArb, now has expanded. It has emerged as one of the most sought after events in the entire country. This event now, this year, has a great value addition because we have collaborated with the Indian Institute of Arbitration and Mediation, and the partnership outcome is IEM is going to train all the awardees as arbitrators, and they will have a full-fledged arbitration training, and they'll be empaneled as arbitrators with IEM and also with the center which we are planning here in our campus. Again, that the Center for Conflict Resolution is being inaugurated along with the valedictory event of this competition, and I believe that it is a perfect occasion to start a fully functional arbitration center in our campus. It's going to be an institutional arbitration center. Initially, we will be hosting it as an affiliate of Indian Institute of Arbitration, but then again, we'll be going for a registration, and probably will get the support of the court, and we'll be able to train the students, we'll be able to host arbitration matters, commercial arbitration also in this campus. So, and then apart from that, we have several other academic partners and knowledge partners. I appreciate the support of ICD, whose rule is being followed in the competition, which all the participants are familiar with. and Society of Indian Law Firms is also a knowledge partner, and the BDN Chambers, Advocate Deepak Narayan is the one who has drafted the Moot proposition, and you also have academic partners like universities. Everything looks well organized. The credit goes to my team in School of Law, my faculty members, the team headed by Shraddha, Sanya, and the volunteers. You took a lot of effort to organize all these. And I thank all the judges who expressed their willingness to join us. But I think I'm taking a lot of time. I would rather go to my assigned role of welcoming the guests. I take this opportunity to extend the most cordial welcome to Justice Koteshwar for gracing this occasion and being here to interact with our students. Professor Kim has always been there, and most affectionate welcome to you. And my friends, fellow colleagues, Major Sharma, Honorable District Judge of Sona, Seema Dalal, and thank you, ma'am, for joining us. Even though it is a protocol visit, but you are a part of, she's also a parent of the School of, the World School of GDGU. And of course, all my faculty members, heads of institutions, and the stars of the day. Of course, the teams from all top-notch schools across the country. And of course, I extend a most cordial welcome to all those who have gathered here, all invitees. So next 2 days, I know it's going to be a battle. I mean, you all are here to win, but the true winners will going to do something marginally different, and that's going to give them the award of winners. Have a great day ahead. Thank you so much, and let's look forward to have a wonderful event. Thank you. Thank you so much.
Thank you, sir, for your warm and inspiring welcome address. Your words have truly set the tone for this prestigious competition, and your unwavering support continues to drive the excellence at the School of Law, GDGU University. Your insightful message reinforces the significance of arbitration in today's legal landscape and highlights the invaluable opportunity this competition provides for aspiring the legal professions. As we continue with this prestigious occasion, it is our privilege to hear from the esteemed leadership of GDGU University. A visionary in the field of education and an advocate for the academic excellence, our Honorable Vice Chancellor has been instrumental in fostering an environment that nurtures learning, innovation, and global acumen. It is with great honor that I invite Professor Dr. Kim Menezes, Vice Chancellor, GDGU University, to deliver the presidential address for the CIArb International Commercial Arbitration Moot Competition 2025. Welcome you.
Honorable Mr. Justice, esteemed dignitaries, faculty members, students and participants. It's a privilege to welcome you to this very special occasion. Before I begin, I would like to extend my deepest gratitude to Justice for taking time out of your very busy schedule to grace this occasion. Your presence is an immense honor for us, and we sincerely appreciate your support towards academic excellence and student engagement. Would also like to thank Honorable District Judge Dr. Seema for taking time to come to campus and be a part of this. At GDGU University, we have always strived for academic distinction, fostering an ecosystem where education, research, and industry integration come together. Over the years, we have built a strong presence in India's higher education sector, offering students a world-class learning experience that goes beyond textbooks. Our School of Law has been a driving force in this journey, rapidly growing into centers of excellence. Through cutting-edge curriculum, industry collaborations, and an emphasis on experiential learning, the law school has become a place where future legal professionals are nurtured to meet the demands of an ever-evolving legal landscape. One of the defining aspects of our law school's success has been its commitment to mooting and advocacy training. The GDGU CIArb International Moot Court Competition has over the years set a benchmark in the legal education space, attracting some of the best minds in advocacy. It stands as a testament to our dedication to fostering legal acumen, critical thinking, and advocacy skills in our students. As we gather today to celebrate this momentous occasion, we reaffirm our commitment to academic excellence and innovation. GDGU University continues to shape the future by providing a platform where students can challenge themselves, grow, and make a lasting impact in their respective fields. Once again, my deepest gratitude for coming all the way to grace this occasion. To all our esteemed guests, our students from all over who have come to Moot, I wish you all the very best and have a great 2 days meeting. Thank you very much.
Thank you, ma'am, for your inspiring and thought-provoking presidential address. Your vision and leadership continue to elevate GDGU University as a center of excellence in education and research. We are truly grateful for your presence and guidance in making this event a remarkable success. We have amongst us the esteemed dignitary who is an SDJM Sohna, Ms. Seema Dalal. We welcome you, ma'am, on this prestigious occasion. A huge round of applause. We also have amongst us Major Kartikeya Sharma, the Chief Administrative Officer of Goenka Group. We welcome you, sir. And now, it is time for the most awaited moment of the evening. We are deeply honored to have with us our chief guest, Honorable Justice N. Koteshwar Singh, Supreme Court of India. Justice Singh's journey is a remarkable testament to the judicial excellence, legal acumen, and unwavering commitment to the justice. Born in Imphal, Manipur, Justice Singh pursued his early education in his home state before completing his BA Honours in Political Science from Kirorimal College, Delhi University in 1983 and his LLB from Campus Law Center, Delhi University in 1986. His illustrious legal career began at the Supreme Court of India, followed by a significant tenure at the Guwahati High Court, where he practiced before the various judicial forums, including the Central Administrative Tribunal and Commissions of Inquiry. Over the years, he has held the pivotal roles including Standing Counsel for the various government departments, Advocate General of Manipur 2007. He was designated as a senior advocate in 2008 and elevated as an additional judge of the Guwahati High Court in 2011 and a permanent judge in 2012. Justice Singh went on to serve in numerous leadership capacities, including the Chief Justice of the High Court of Jammu and Kashmir and Ladakh in 2023. His deep-rooted commitment to the legal services has also been evident in his role as an executive chairperson of the Nagaland and Assam State Legal Services Authorities. Finally, in a historic moment, he was elevated as a judge of the Supreme Court of India on 18th July 2024. With a legacy built on integrity and judicial brilliance, it is truly an honor to have him here with us today. We welcome you, sir, on the stage.
A wonderful good evening to everybody present here. Respected Vice Chancellor of the GDGU University, Dr. K.V. Menzies, Dean of the School of Law, Dr. Jairam Raghunath, Seema Dayal, district chairs, faculty members and other administrative officers, staff officers, and my dear students and ladies and gentlemen. Well, I didn't know that it would take about an hour or so. I will start with 5-10 minutes because time is precious. I can understand evening to have an inaugural function. Normally, we are used to have inaugural functions in the morning, no? In the beginning of the year, you inaugurate the day, the functions, the programs. Like the fake out there when everybody gets tired. When tiredness sets in, people like to go home and relax to have this function. Nevertheless, I am so happy and glad. I am thankful to the university that they said that they would not mind also having in the evening, though I would have loved to do in the morning, but because of my other commitments, so I could not. Thank you very much for inviting me in this very important occasion of the 7th GDGU CI Arbitration India International Commercial Arbitration Competition 2025. Of course, I prepared the speech obviously for the simple reason that I do not go astray when I speak, or I do not miss out an important point which I think is also important to be mentioned in this kind of important gathering. But before I go to my prepared speech, which I hope you will not find it too boring, I'd like to mention that when I enter this, I feel so nice. See, in our times, 80s was still developed. 80s, till 80s, you see, law was not really kind of a preferred profession, kind of discipline. People with law, I mean, I remember in my college days in university, they will look for all various subjects and disciplines, and when they didn't find anywhere, go to this law faculty, get enrolled yourself. There were many reasons, including the reason to have a hostel. You get a hostel, they're very good. Then we have this 12 rupees 50 paise, DTC pass. So these are, real charm for students to continue to study in university. And law faculty used to provide a good reviews. Fortunately, I had decided to do law when I was doing my honors. And again, those were days where law universities were not still there. Professor Menon, he was a pioneer in the field. In fact, I was fortunate to be taught by him in the law faculty. I remember that he went on to Bangalore in the University National. He was, I think, one of the founding members of those who are good to know in this field. So, because the need to have a proper law college dedicated to students like you who are, determined and have decided to be in this field is very important. Not to gather some herds of students and teach them law. That's why I found very nice that kind of feeling when I entered. And of course, much better is the kind of atmosphere, the kind of environment, kind of infrastructure you have here. Moot, nowadays, Moot court was confined to just focus. There used to be Moot court competition, but it was not that as popular, but it was only restricted to perhaps the routine litigation. Arbitration? 1940 arbitration was the law which used to govern at that time We didn't have much idea of international arbitration, much. So I am as good as a student like you, trying to learn about international arbitration. So don't expect me to give a very high sounding, scholarly presentation that you will get it from your professor. I am still learning about international arbitration. Before I go to this my topic more focused, the whole concept of international, it conjures something international, something new, it's a contemporary. Now all over, now there's all these trades going on, international firms coming in India, that kind of image which builds up in our mind. But international trade is something very ancient. In fact, India has been one of the most important trading partners thousands of years before. If you see this trade, silk trade, route, China used to link up from China. They all the way come to China. They would pass through Kashmir because silk trade because I had been in Kashmir, so I saw them. Can you imagine those still the small parts still there? Trade route, silk trade route. If you go to Kashmir, those who are there, it's a wonderful kind of feeling you have. Oh, these were the small stretches where these camels or maybe horses and mules, all these animals used to bring these items from various places and go all the way to Central Asia and beyond, catering to the needs of Indian spices, and also we are getting. So, and obviously there must have been dispute also. I don't think it was all friendly game, something like that. There must have been dispute. How it will be resolved, That's I used to wonder how it should be resolved at that time. I'm sure at a time you won't find lawyers to argue your case. It must be by way of conciliation, mediation, isn't it? There was the international court at that time. You won't have international court in the border, So obviously there was only this arbitration or maybe the conciliation must be the preferred mode of dispute resolution. And see this South Asian country also. See, hundreds of years before, in fact, all this Java, Sumatra, if you go, what is that? Cambodia, you see the one god, all these, there are Indian civilization that touch these areas. And obviously there must have been trade also. So when we say international arbitration, so let us not confine only ourselves with the present. What I'm trying to say is that we have a deep-rooted and a very strong, vibrant history behind us. So with that note, I would like to go through my prepared speech. Well, it is indeed both an honor and a privilege to address you in this inauguration of the 7th GDGU Arbitration India International Commercial Arbitration Moot competition. In the next few days, you will be witnessing exemplary advocacy, rigorous reasoning, and impressive display of skill in the domain of international arbitration, particularly in the realm of intellectual property disputes in the pharmaceutical sector. International commercial arbitration has long stood as the cornerstone of dispute resolution in global trade, offering neutrality, flexibility and enforceability in cross-border conflicts. Today, as we navigate an era of unprecedented technological innovation, intellectual property has emerged as a vital asset, especially in the pharmaceutical industry, where the intersection of business, public health, and legal framework creates a unique challenge. The role of arbitration in resolving these disputes efficiently cannot be overstated. Having said that, one of the most important dynamic areas of arbitration today is intellectual property disputes, particularly in the pharmaceutical industry. This sector is heavily dependent on patents, trademarks, trade secrets, and licensing agreements, making arbitration a preferred method of resolving dispute efficiently. Events such as today's Moot competition hold a unique place in the realm of legal education. These competitions are not just about winning or losing, they contribute to the development of a skilled and effective lawyer. Law school is often focused on teaching us what law is, but competitions such as IP arbitration Moot train you to marshal a complex set of facts and present them in a favorable light to the arbitrators. As you begin your legal career, you will learn this, that it is a very important as knowing knowledge of law. The subject of IP arbitration is not one commonly taught in law school, but through your participation in such moots, the doors of entirely new practice areas can open up to you. This moot highlights the importance of procedural autonomy, the enforceability of arbitral awards, and the delicate balance between state sovereignty and investor rights in international trade agreements. More importantly, this competition will reinforce the value of arbitration not only as a dispute resolution tool, but as a mechanism for inculcating cooperation, safeguarding intellectual property, and ensuring that innovation thrives without being hindered by prolonged legal battles, wherein the pharmaceutical sector in particular depends on a swift and expert dispute resolution to uphold patent protections, facilitate licensing agreements, and navigate the regulatory complexities. International commercial arbitration evolved out of important treaties and international agreements, most important of which are the Geneva Protocol of 1923 and Geneva Convention of 1927. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention in 1958, had ushered in the contemporary era of ICA. The New York Convention streamlined the enforcement of arbitral awards across jurisdictions, significantly enhancing the reliability of arbitration as a dispute resolution method. The establishment of the International Center for Settlement of Investment Disputes in 1965 and the adoption of the UNCITRAL model law in 1985 further standardized procedures and promoted arbitration acceptance on a global stage. International commercial arbitration is now a well-established practice widely regarded as a preferred method of resolving cross-border disputes due to its flexibility, enforceability, and neutrality. It is important to note that development and institutionalization of international commercial arbitration cannot be attributed only to treaties and international agreements. One needs to take into account two other factors. Firstly, the establishment of arbitral institutions. Secondly, the growth of ad hoc arbitration. Establishment of arbitral institutions has provided commercial entities the choice to resolve their disputes at these institutions rather than the court of law. These arbitral institutions determine international commercial disputes in accordance with their published rules to which the contracting parties have agreed to abide by. For example, the International Chamber of Commerce published its ICC rules of arbitration first in 1922 and the latest version in 2021. The Hong Kong International Arbitration Center has its HKIAC administered rules with their latest versions updated in 2024. Further, because of the growing number of international commercial and industrial disputes, companies have also opted to determine the disputes by arbitration by an arbitrator or arbitrators previously agreed on, or appointed ad hoc by some specified appointing authority. In such cases, the dispute would be governed by rules agreed upon by the parties, such as the ancestral arbitration rules, which were updated in 2014. Arbitration law has now rapidly gained ground as the preferred mode of resolution of IP disputes. While it is still the case that some types of IP disputes are litigated predominantly in national courts, the number of IP-related cases going to arbitration continues to grow. Indeed, one of the noticeable trends in international arbitration in the past several years has been the growing use of arbitration to resolve IP-related disputes. What accounts for this growth? Recent changes in the national laws in Singapore, Hong Kong, and elsewhere have affirmatively sought to make arbitration more attractive and effective in resolving international IP disputes. And the historical resistance to the arbitrability of IP disputes has given way in most jurisdictions to a more liberal and a pro-arbitration approach, and to the perception that arbitral tribunals should generally be free to adjudicate IP rights, at least on an inter-parties basis. International arbitration provides an appealing alternative to adjudication in national courts for many international and cross-border disputes. Fundamentally grounded in party autonomy, arbitration enables parties from diverse jurisdictions and legal traditions to agree and resort to efficient and specialized dispute resolution mechanism tailored to their specific needs. Such customization particularly complements common features of international IP disputes. Now, what are the advantages of arbitration? Perhaps the most important is the forum neutrality and the choice of arbitrators. To assist this in this regard, there are many arbitral disputes that maintain panels or listing of arbitrators specializing in IP disputes, including WIPO, HKISC, CPR, and SISC. It's a very interesting development in law. See, when we go to courts, whether it is national, domestic courts, we can't decide which judge that our cases should be decided, because that's what's called forum shopping. In fact, that is discouraged. It's not considered to be appropriate that, yes, the parties decide who will be the right judge. But arbitration is something very unique. This is a new development. I mean, it is inherent, it's an important part of this arbitration proceeding that you can choose your arbitrators. See, that's very important, which leads to kind of more informal, kind of congenial atmosphere where both the parties know the arbitrators that they are going to be a neutral arbiter. It's a very important development in law actually. Now, what are the benefits? The enforceability of this arbitral award. See, what has happened is that, see, when we see a lot of foreign judgments being sought to be implemented in the country, then you face with all difficulties, because we have our own laws to deal with how to execute a decree. We go by our own, not by the jurisdiction or the country in which this decree or the order was passed. So all these are resolved in a much more efficient and amicable manner because of the need to have this enforcement of international arbitration. That gives a very very comfort level for the parties without having going through all the nitty-gritties of trying to adjust to the domestic legal requirements. This is very important. In fact, this New York Convention ensures that the recognition and enforcement award should be done with minimal formalities. This is a big advantage, because after you have got the decree in your favor, if you are able to enforce it, what is the value of that? Therefore, this entire regime has worked out so that the international awards can be easily implemented in various jurisdictions. This is a big advantage. Then of course the procedural flexibility also. Otherwise in domestic law you have to follow your CPC, CRPC, Evidence Act. In arbitration, as you know, these are principles are applied, but they don't go strictly by the provisions of that. So you should be the basic principles of giving opportunity of being heard, then giving a reason order. These are basic elements of justice. The legal system are there, but you don't have to get stuck up with this order 1, order 9, order 10, CPC, this CRPC. So these are big kind of relief for the parties also. If you are able to insist on the principles, if your principles are adhered to, there is hardly any way it should come in the way of an effective proceeding and also making of award. You have one great advantage of the international arbitration, for that matter for national arbitration also, because international arbitration is the extension of that to the international era. And in fact, as we all know, with the adoption of Arbitration Conciliation Act 1996, much has been incorporated also. In our time, we didn't have the 1940, as I mentioned again, we didn't have this concept, because at the time there used to be every stage, even in the Arbitration Act, there used to be various stages where the court could intervene and interfere. But here, hands off. That's the attitude which is adopted by the court today, in not only international arbitration but also in national arbitration, which is a great advantage for easy, fast resolution of disputes. So therefore, it leads to cost-effective, much more cost-effective than rather than having 3-4 forums trying to resolve a dispute. Because see, as a company, you are working in various parts of the nation, from the south to the east to the north, west. There may be a dispute. There may be various, then different countries also of the same product. For example, an Indian product being sold in different countries. Now, different countries will have different rules, different norms, different jurisprudence. Now, international arbitration allows it to conciliate. One big advantage is that. Then, of course, the most important is confidentiality. How do you maintain confidentiality? In normal court proceedings, you have to disclose all your documents, or whatever you are going to rely. There may be trade secrets, especially because the Moot is about the pharmaceutical. You like to keep your, the formulas, your combination very, close to yourself. Then the arbitration proceeding allows you to maintain that confidentiality. It's a big advantage which you don't have it in normal court proceedings, because normal court proceedings are public, is open to public, is open to the scrutiny of not only the parties but also the public, where this confidentially you are able to maintain arbitration very effectively. Then of course the consensual nature of arbitration proceedings, because both of them can agree also what kind of procedure, how kind of procedure we should adopt. So the flexibility. Otherwise, in a normal court proceeding, you can't decide the procedure. Procedure is laid down by the law statute. The court also cannot afford to go beyond that. It is only perhaps the Supreme Court of India under Article 142 that they can depart from these rigid procedures. But all high courts, all courts, district courts, they are bound by these rules and norms. You can't deviate. Now, this arbitration forum always gives you that the kind of amiability of the proceedings, and of course the speed and efficiency. Speed and efficiency is also important, because see the problem we face in judiciary today. I mean, as the Supreme Court, every day when we meet together, one of the most important issues we discuss is the huge pendency of cases in all disciplines, whether it is a family dispute, whether it is a criminal cases, whether it is a negotiable instrument, NI cases, the huge pendency because of which we are not able to deliver it properly. Now, therefore, because of this delay, as this goes, maxim goes, the delay defeats justice, it's a big challenge before us. Unfortunately, because of this forum arbitration forum, which is now of course open to an international forum also, this is an area which can be reduced to a great extent. the speed and efficiency of arbitral proceeding is a distinct advantage over the more rigid formal part of the court system. Now, of course, there is a very important principle also in arbitration, the principle of separability or severability of the arbitration clause. See, we all go by this contract. We said yes, parties are bound by the contract. Arbitration clause is a part of the contract. So if the contract itself is declared null and void, declared illegal, your arbitration clause also will go. So how do they resolve the dispute? So this is a very innovative interpretation that, well, even if the agreement, the contract which the parties have agreed is declared null and void and illegal, yet that survives. That agreement to refer to arbitration survives, because that's the core of your dispute resolution mechanism. Otherwise, if a contract is declared illegal and you are compelled to go to the domestic court or the other formal forum, the whole purpose of speedy resolution gets defeated. Therefore, this concept of severability is very unique to this arbitration clause. So we always see. Now, okay, it doesn't matter if the arbitration, if the agreement goes, parties are unable to execute their terms and agreement, fine, no problem. But this arbitration clause will remain. That's the principle of severability and separability. So these are important features and advantages of arbitration, which is equally true of international arbitration. Now, of course, as I mentioned also, our tradition goes deep in thousands of years, but the modern arbitration system, as we know, was introduced obviously in the British era, where we had this Indian Arbitration Act of 1899 made by the British, which was based on the English Arbitration Act of 1889, and it was applied only to the presidency towns of Calcutta, Bombay and Madras. Of course, then changes were brought in. We had seen in the post-independent era also the second Civil Code of Civil Procedure 1908 provided the recourse to arbitration. Because we realized that this is one of, because as I mentioned again, huge pendency of cases, the courts are not able to deliver for various reasons. Now, what is the way out? Obviously, the problem has to be sorted out. Therefore, ADR being really emphasized upon alternative dispute resolution mechanism. In fact, commercial courts also, that there is a mandate that before you go to trial, that you must first refer to this ADR for possible resolution. Which is true also in many other statutes also, even the family courts also will try to resolve the issue if in case of various divorce proceedings and others, family dispute also. Therefore, the attempt focuses on conciliation, focus on mediation, focus on arbitration, the alternative method of resolution, which is very much part of the international arbitration system also. In today's, of course, coming to the contemporary India, India has taken very significant steps to position itself the hub of arbitration. Currently, international commercial arbitration alongside mediation is the most preferred mode, as I mentioned, and it is becoming very popular also. This is evident from the increasing number of cases involving Indian parties across various arbitration institutions. India has topped CIA's list of foreign users for 4 years in a row, and the past 2 years saw nearly 300 Indian parties at CIAC. Singapore remains the preferred seat for Indian related arbitrations, while London and Dubai are also very popular choice amongst the parties. Indian parties also appear to be the top 10 users of ICC arbitration. It must be highlighted that in 2023, the ICC administered 890 cases with a significant number of parties and arbitrators from India. In 2023, 52 Indian parties were involved in ICC arbitration cases, representing 2.18% of the total 2,389 parties globally. Indian parties constituted a major chunk of the domestic disputes referred to ICC arbitration, reflecting the growing preference for ICC arbitration even in local disputes. The statistics on ICC resolution also depict the diversity of sectors where Indian parties have chosen international arbitration spanning across construction, engineering, energy and industrial equipment. The multitude of data brought together reflects not only India's growing integration into global trade and commerce, but also brings forth challenges such as the underrepresentation of Indian arbitrators, despite India's significant participation as parties. Indian arbitrators remain underrepresented with only about 1.34% of the total appointments in 2023. The establishment of Mumbai Center for International Arbitration in 2016 and amendments to the Arbitration Conciliation Act 2015 and 19 reflect India's commitment to creating a pro-arbitration environment. The institution has maintained efficiency with 93% of all arbitrations completing within 18 months and none being set aside by the courts. It's a remarkable achievement, which shows how India is progressing in this field of arbitration. India's evolving legal framework and growing institutional support demonstrate its potential to become a leading destination for ISA in the future. Navigating through the nascent stage of progressing from ad hoc arbitration towards institutional arbitration in the wide arena of international trade and commerce, India is on its way to become a global arbitration hub, as is evident from the recent developments. For example, the India International Arbitration Center Act 2019, which was enacted to create an independent autonomous body for international arbitration in commercial disputes, followed by the notification of India International Arbitration Center Conduct of Arbitration Regulations to 2023, with a special focus on the efficiency and the time-bound nature of the process. Now, major arbitration resources in India include the Indian Council of Arbitration, the ICATR, the Federation of Indian Chamber of Commerce and Industry (FICCI), the India International Arbitration Center, the Arbitration Bar of India, and the agreement for establishment of a regional facility of the Permanent Court of Arbitration in India. These are very important developments which are taking place in India. The PEC is one of the oldest and the most respected international arbitral institutions. A regional facility recently set up in India would not only elevate India's status by enhancing infrastructure and expertise, but also increase accessibility and cost effectiveness, the major advantages that arbitration seeks to provide to stakeholders. Coming to this Arbitration Bar of India, it was inaugurated in May 2024 with a mission to promote excellence, integrity and innovation in arbitration practices. The ABI seeks to establish a specialized arbitration bar that is competent and professional. Its members will work to promote ADR mechanisms, lobby for legislative reform, and provide a platform for continuous professional development. Ultimately, the ABI aspires to encourage the choice of India as an arbitral award. So we can see a lot of future members of the bar now. Further, with the objective to provide facilities and administrative assistance for arbitral proceedings and the maintaining panels of arbitrators, ICATR is currently working out 2 regional centers in Hyderabad and Bangalore. The ICTR rules provide for its functioning as the appointing authority ad hoc arbitrations based on agreement between parties. Now, there are some challenges before. What are the challenges we face in India? Though many strides have been made, one of the important challenges, is that that while building a consensus to opt arbitration as a means for dispute resolution, it should accord with the time and money. While the Act, which we have mentioned, our Act, this does not accord statutory limit on the timely resolution of cases and puts a cap on the amount of money to be spent, certain issues persist. Normally, the lower courts take about 24 months to handle challenges to arbitral awards. Then High Court again take about 12 months. And if in the Supreme Court, about 48 months. So roughly it takes about 2,508 days, which is not a very impressive figure because 7 years to resolve challenge arbitral awards, I'm talking of the normal awards from history. It's not very impressive. Something needs to be done about it. While the 2015 amendment said, because we know 2015 amendment said that arbitration awards will be made within 1 year. We know all, because first of all the problem comes up, appointment arbitrator, there is a whole dispute. The reference to the Chief Justice for his nominee for appointment arbitrator, it takes a lot of time. Then sometimes for reasons there is not able to be completed, and you have to seek the for extension of time from the court. Then there will be a hurdle. So these hiccups are still there in spite of our statutory requirements. Now another area is the challenge regarding the institutional reforms which is also required. We have to learn about from Singapore, which is in a very advanced kind of stage, where now it was initially dependent on the governmental finance, but now it is a self-financing institutions. So this is also something which we have to learn from other examples. And of course, another challenge is to, as I mentioned, also lack of experienced lawyers and subject matters experts in this arbitration pool. This is also another area. We have to have more experts who can act as arbitrators, and of course, the fee structure also needs rationalization. I can't comment on the fee structure. I am told that astronomical figures are being charged. But of course, I can't say because I have not done any auditing of the arbitration. But yes, this is a big issue that the kind of the cost effectiveness for which was meant perhaps is being diluted because of the huge costs involved in payment. There are a lot of talks going on, also discussion in this level. We are also concerned that the arbitration which are supposed to be cost effective is it becoming really costly for many of the parties. These are issues which we need to consider, examine. Yes, so there is a big challenge that number one, that it is effective, so there needs all the institutional challenges needs to be looked into, then the fee structure, the availability of experts in the domain, experts in areas of, there are various kinds, as I mentioned also, various areas of disputes, mechanicals involving, then this pharmaceutical, a normal lawyer also can't judge also. I must frankly say that, it is not a cup of tea for a normal lawyer to go into the nitty-gritties of these issues. This requires real experts who are also trained to be legally trained. So it's not merely sufficient to have experts also, but the experts themselves must also have this basic knowledge of law. So it's a big challenge. In fact, as I mentioned, because the AI is going to be a big problem. We all say that we must AI also in our judicial system. But the problem is that those who are experts in AI, they have no knowledge of our legal system. And those who are experts in law, they have no idea of this. So there has to be a merger of this. Therefore, I am really looking for those students who are experts not only in law but also in digital world also. Then they can really evolve. There now I'm told that people are using ChatGPT to decide cases. Lawyers are frequently, they do ChatGPT to address the courts. I know. Lawyers, they're very smart. They just, any question being asked by the court, immediately you quickly do a research in ChatGPT. And of course, there was a report also in some high court, some judge also referred to ChatGPT to decide some bail matters. But as you know, those who are little bit acquainted with AI, there is something called black box. The whole concept of black box, I suppose you know that. The black box of this AI, how it works, people don't know. Because black box is still a mystery. How this AI, how they give these answers. It is not only by collecting data from various parts of the world and giving an answer. See, this AI also does its own permutation, combination, works out his own formula inside. That we don't know how apart from the experts, with the normal lawyers and the judges, we don't know how therefore, how can we accept that answer given by that AI, ChatGPT, which is based on certain formulas which we are not aware of. You see, whenever we as judges or lawyers, for any conclusion to arrive at, there must be certain parameters. Whether these issues or the problem meet these parameters, the legally accepted parameters, then we say it is valid. Whether you agree with it or not, that's a different issue, but these issues must meet the parameters laid down by law. Then you say this is valid, this is illegal. But when you don't know the parameters in which these AIs work, how will you say this is correct answer? May be correct. I am not saying that, but we don't know, because as justice delivery system, the law must be based on certain ascertainable principles. That's what. So these are big challenges. So then coming back to this arbitration, what we can do is to learn from the experience of others also. As mentioned, Singapore is really a hub of the arbitration, and India wants to be also. And India has a potential, as I mentioned also, because we have this tradition, and we have a large pool of intellectual pool in the world. Most of these today's world's companies, software companies are headed by Indians. So it shows that we have the foundation, we have the material, we have the resources, but how to channelize it? That's a big challenge for which this Moot, this competition today also is going to shed the roadmap. We are going to part of that historic movement which is being built up to make India a really hub of arbitration. And I must congratulate the university and of course the students who have come from various universities to take part in this. It's a very challenging, immersive trend, but with huge potential. Today's world is a world where we cannot live in isolation. Yes, different countries may have different ideologies, different political setup, different approach, and we can see. But when it comes to trade, the same principle will align. See, irrespective of the culture, irrespective of the political system, because you will not say that I will not purchase this product because it is built by a totalitarian, There may be issues about all this direction, and there are also issues coming up, part of it. So what I'm trying to say is that international arbitration is inevitable because of the increasing international relationship between the nation states. And it's a big potential, it's a huge potential. We must take a full advantage of it. And I must congratulate the universities and the participants for being part of this ongoing movement. Thank you very much.
Thank you so much, sir. On behalf of GDGU University and everybody present over here, I extend my sincere gratitude to you for sharing your valuable and insightful thoughts on the Moot Competition 2025. Your words of wisdom have provided deep insights into the principles, significance, implementation, and effective proceedings and development of arbitration in today's legal landscape, and have undoubtedly inspired our participants as they embark on this rigorous and enriching journey. of course with the help of the digital technology, I must say. We are truly honored by your presence and grateful for the time and knowledge you have shared with us today. Thank you once again for your encouragement and support. As we draw the inaugural ceremony to a close, I now invite Ms. Sania Kapoor Wadhwa, Assistant Professor, School of Law and Faculty Co-Convener of the Moot Court Society, to deliver the vote of thanks.
A very good evening to your Lordship, to the dignitaries and all the participants. I'm going to keep it really short. I know you all want to have the draw of lots and start the Moot competition. I just wish you all the very best for the next 2 days. It's going to be enriching for you and us both ways. Also, your Lordship, you've heard it from the horse's mouth actually as to what needs to be done and what is arbitration. So your major problem should be solved by now. So I like to extend a very, I'm just speechless right now because, having a Supreme Court judge before us and giving us such words of wisdom is completely unforgettable. It should be a part of everybody's course of listening to sir. Thank you so much, sir, for coming here. And now I would like Neera ma'am to take over.
Thank you so much, ma'am. To conclude this grand evening, on a patriotic note, may I request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाए सब जय गाता जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
With that, we officially conclude the inaugural ceremony of the 7th GDGU CIArb India International Commercial Arbitration Moot Competition 2025. A sincere thank you to all our distinguished guests, faculty members and participants for gracing this occasion. Let the competition begin. Wishing all the participants the very best. May the best team win. I request everybody for the group photograph, please.